Hey class, Mr. Stewart here. This is going to be the integrity video for chapters 10 and 11, which is for the fall 2015 term. Is going to be week 9 out of the semester. So can't believe we are over halfway done with the semester at this point. So hopefully you've gotten the midterm exam taken at this point, and you are continuing on with your normal weekly work here in week 9. Now this week I'm going to spend a few minutes talking about chapter 10 and a few minutes talking about chapter 11. I'm kind of going to hit some of the high points and some of the things that I think that you'll run into, and some of the issues and concepts that you need to be aware of in regard to these two chapters. I'm going to try to keep it as brief as possible, just so I don't drone on. These are some of these topics that we could have a whole class lecture on each one of these chapters without any problem whatsoever. So I'm going to try to condense both of them down into about 20 to 30 minutes, and I hope I don't go too much over 20. So chapter 10 has to do with where the exclusionary rule does not apply. Now last week, if you remember, and you saw in the course, I didn't record a integrity video, but I uploaded a video for you to watch in regard to the exclusionary rule, and it was kind of dated, but it was a lot of good information, because some of the stuff just doesn't change. Okay, so with that being said, at this point you should have a general understanding of what the exclusionary rule does, and what it effectively does is it says that good evidence obtained through bad means would be excluded at trial, therefore you wouldn't be able to use it. And so illegal, unethical searches that do turn up good evidence of a crime, the actual illegality or the unethicalness of the search would deem whatever the fruit of that search is to be inadmissible. So, but just also remember that in the law, whenever you have a rule, you probably have exceptions to the rule. So that's what we're going to be talking about in chapter 10, where the exclusionary rule does not apply. So these are the general rules. I'm going to get into a little more specifics of some of these here in just a minute, of when the exclusionary rule does not apply. And that means that evidence would likely to be admissible, even if the search may be questionable. So if it's a civil case, if it's a non-criminal issue, it doesn't really matter how the evidence is obtained. If they get it, it can probably be used. And I know that sounds kind of weird and kind of off the wall, but remember, there is a much lower standard of proof in a civil case than there is a criminal case. So we don't hold evidence to the same standard either in a civil case. In fact, hearsay is admissible in a civil case where it would not be admissible in a criminal case. Exclusionary rule does also not apply in situations where consent was given, and it's important to understand that the consent was given by somebody who had standing. And I'm going to talk about what standing is in a few minutes. And the exclusionary rule also does not apply when this evidence is obtained in a private search by a private person. Now there is a caveat to this one. Basically, the government cannot be involved in either directing or asking for the private person to engage in the private search. If that is the case, then it would be considered a government search, and the exclusionary rule would apply. Because the exclusionary rule does not apply to private people engaging in private activities. Even if those activities are illegal, the exclusionary rule does not apply there. So keep that in mind as we go through some of this here in just a minute. Now, there's plenty of court cases in your textbook that make the examples. Always read over these court cases. I'm not going to go into detail in regard to the court cases, but I think it's important that you see the case law and how the courts were able to make the decisions and the rules that they make in regard to evidence. So read over the Bordeaux versus McDowell, U.S. versus Janus, and U.S. versus Drayton. I think you're going to find that those are definitely applicable in this chapter for this case. So now I want to go back and talk about consent searches here for just a second. Understand that a police officer can ask for consent anytime. There's nothing wrong with them asking to search something, and then if consent is given, if they find something, then that would be considered evidence of a crime or contraband. Then there's nothing wrong with using that against the person, because it's not necessarily a government imposed search. It is a search that was consented to through the free will of the person giving consent. Now understand that when consent is given, limits may be placed upon the consent. For example, somebody that owns a house, you can say, yeah, you can come in and search my house, but everywhere but the bathroom. You can't search the bathroom. And if you don't find anything illegal in that residence without searching the bathroom, you cannot legally search the bathroom because there was a condition or a limit placed on the consent. And you cannot violate that because they are actually giving you permission, and the permission can be limited. It can also be revoked at any time. So you could be in the middle of the search and they say, oh no, you're done. Don't search anymore. And if you have not yet found anything that is also evidence of a crime, you would have to stop that search and leave that residence. That is their right. They have an expectation of privacy. Now, there is an exception to when consent is necessary, and that is in emergency circumstances. Your book calls them exigent circumstances. So, if emergency circumstances exist, consent is not needed to enter a premises. And a good example of that may be, if you can remember when the Olympics were in Atlanta several years ago, there was a bomb that went off. Well, the Atlanta police got a tip that there was another bomb that could potentially go off at any given time in another residence across the street from the Olympic Stadium. And they went to that residence. Nobody answered the door. They forcibly made entry into the residence and searched the residence for said bomb. Now, I don't remember if they found a device or not, but the issue here is whether or not they had a legal right to enter and search that residence without consent. And I think that would fall under this exigent circumstances or emergency circumstances exception to when consent is necessary. So consent can be given at any time, although limits in regard to the scope and the duration may be placed on the consent, and the consent may be revoked at any time. You also cannot compel the consent. It has to be freely given, knowingly and voluntarily given. Okay? So keep those terms in mind. Again, here's another court case. And it looks at the fine line between who has the right to give consent, especially in a residence that is cohabitated. Now, when we're talking about consent, we also have to understand a concept called standing. And what standing is basically who has an interest in the search and the result of the search, so to speak. So a defendant does not have standing to argue suppression of the evidence if their right of privacy has not been violated. So the only time you can argue standing, that you have standing in the residence or standing in the vehicle, is that if you have an expectation of privacy in whatever it is. I mean, you do not, for example, a phone booth. You do not have an expectation of privacy in a phone booth. It's in the public. It's very likely somebody could hear your conversation with someone else. So therefore, you don't have the right to either refuse the search of that phone booth that you're in, or to place limits on consent if somebody comes up and if a police officer comes up and even asks you for consent to search that phone booth. You don't have a legitimate expectation of privacy there, like you would in your home, or like you would to a certain degree in your car or a hotel room or something like that. So just keep in mind that like in a residence, if you rent the residence, the renter, the person who is on the lease, has the expectation of privacy. If there is someone staying at the residence, they probably would not have standing. But if they are actually living there, they may be able to have standing, that'd be a case that the court would have to look at. However, the landlord of the residence would not have standing in order to give consent for the police to search, because the landlord has no expectation of privacy in a location in which he is rented out. He's given up his expectation of privacy in that residence because he now has rented it to somebody else. That expectation of privacy has been transferred over to the renter. Okay? So in order to succeed in the motion, the defendant must show that his rights were violated, not the rights of some other person. So the right or the expectation of privacy rights of the defendant must be violated in order for them to have standing in whatever that location is. So here's another court case, Rakes versus Illinois. Only people with a legitimate expectation of privacy can object to an unlawful search and assert standing. I think that's what I just said. All right, abandoned property. Here's also an instance where the exclusionary rule does not apply. So if by conduct or words the defendant shows that he or she has relinquished the expectation of privacy in property, the object can be used as evidence. For example, if you throw something away, if you take your garbage out to the curb and you leave it for the garbage man, you are at that point abandoning that property, and it is subject to search by anybody at any time. When I was a private investigator, I used to grab people's trash in the middle of the night or early in the morning, try to beat the trash man if I needed some information about somebody, because people throw away the darndest things and the interesting things you can get good information from, because they don't necessarily expect somebody to be going through their trash and searching it for that information. They expect the trash man to come pick it up. But once you bring your trash out to the curb and leave it for the trash man to get, actually anybody can get it. It is considered abandoned property. Same way if you put a chair or a couch or something else out there at the curb, and you see these ads on Craigslist that says curb alert, come get something, it's abandoned at that point. And once you abandon it, you have no expectation of privacy, and therefore you have no standing in the property any longer. Now, you can't go up on somebody's back porch and get their bag of trash that they've not set out for the trash man yet. They just happen to set it outside, but once it's at the curb, it is considered abandoned, and the exclusionary rule does not apply to that. So whatever you come up with out of that trash would be admissible at court. Again, throw away as a type of abandonment. This slide just talks about that. Make sure you read over that. Let's see, denial of ownership as a form of abandonment. If somebody says, no, that's not mine, then okay, fine. That means you can search it, and the exclusionary rule does not apply. If nobody claims ownership, such as, let's say you get wind of drugs being shipped in a piece of luggage at the airport, and you were waiting for the potential suspect to claim their baggage so that you can then stop them and question them and potentially search their baggage. Let's say that they see you and they decide, I'm not going to claim my bag, I'm just going to leave. If that bag is left at the airport at that point, that's considered abandoned property. And if you happen to see their name on the bag and you approach them saying, is this yours? And they say, no, that's not mine. Well, it's got your name on it. I don't care. I don't know who somebody else could have put my name on it. That's not my bag. I don't want it. I'm not taking that home. Then that is a denial of ownership, and that is a form of abandonment. Once you have denied the ownership, you do not have standing in the property any longer, and it can be searched without worrying about violation of the exclusionary rule. So here's some examples. Denial of ownership of an apartment, denial of a satchel the defendant hid after a car accident, denial of luggage in the trunk of a car, train passengers, denial of a garment bag, airport denial of luggage. So, basically if they say, no, that's not mine, then you can search it without any problem, and the exclusionary rule does not apply. Again, evidence obtained from garbage, I talked about that just a minute ago. trash receptacles kept inside a home or a garage do have Fourth Amendment protection. But once they place it at the curbside or in a common trash receptacle, such as a dumpster or something outside the home, then it's generally held to have abandoned the property, what I just said a minute ago. All right, so the right to privacy or expectation of privacy, the Fourth Amendment protects people, not places. When a person knowingly exposes to the public, even in his own home or office, is not subject to the Fourth Amendment protection. A reasonable expectation of privacy exists only if an individual actually expects privacy and that individual's expectation is reasonable. So it doesn't matter, even if you're in a place where you have a legitimate expectation of privacy. Say you put something in the window. Let's say you hang a string with a joint on it inside the window of your home. Just because your home is your castle and you have a legitimate expectation of privacy in your home, you have made that illegal contraband visible to the public, and therefore the police could potentially enter that residence in order to seize that contraband without worrying about the exclusionary rule, so to speak. I don't think it would probably work that way, but in theory, the expectation of privacy is diminished once you have put something in the public view. So you may expect privacy in your own home, but that expectation would be unreasonable once you have put something into the public view, like hanging a joint, a marijuana joint, on a string on the window, that if somebody walks by, they would immediately recognize that as contraband. Make sense? Stone versus California, we'll read over this court case as well. Persons renting hotel rooms, storage lockers, or vehicles can have a reasonable expectation of privacy. It's not limited to a permanent residence. This right can expire if the tenant is served with an eviction notice or when checkout time expires. So basically what that says is that if you rent a car, you have the same expectation of privacy in the rental car as you have in your own. If you rent a hotel room, as long as it's not time to leave, checkout time, or the bill's not been paid, then you do have a legitimate expectation of privacy in that as well. Now, curtilage. Curtilage is a legal term that you do need to understand, and that is defined as the area close to a home or immediately surrounding a home where persons may assert a right of privacy. For example, let's say you have a house that sits on 20 acres, and let's say the 1 acre lot right around the house is what you use on a normal, ordinary, everyday basis. That's the yard you cut. That's the yard where your kids play. You have storage buildings or whatever in that yard. All of that yard would be considered your curtilage. You have a right to privacy not only inside the home, but in the curtilage around the home. Let's say there's a barn on the back side of that 20 acres that you may go in twice a year for whatever reason. You know, maybe you're just not even using the property, you just own the property, not really using it for anything. Maybe you mow it a couple times a year, but you don't use it every day. You would not have the same expectation of privacy in that barn as you do in your home, in the immediate area surrounding the home, because that barn would not be considered your curtilage. So you do have a legitimate expectation of privacy in your curtilage, but outside the curtilage, on a piece of property or around a home, if it's outside the curtilage, you do not have a legitimate expectation of privacy. Again, here's another court case to take a look at. Where does the exclusionary rule not apply? If something is found in open fields or evidence is discovered in plain view, if it's obtained where the good faith rule and the honest mistake rule apply, if you believe you're doing what's right, or you see evidence in that open field, or it's just in plain view, exclusionary rule does not apply. And any evidence obtained by a police officer who has a lawful authority to seize that evidence, the exclusionary rule does not apply, because that would be good evidence obtained through good means, not good evidence obtained through bad means, which would trigger the application of the exclusionary rule. So read over these slides in regard to plain view. That's pretty straightforward as well. It's in your text also. Good faith, we've talked about that also. The honest mistake, read over that as well. Because I want to move on here to chapter 11, but I just want to make sure you understand this idea of expectation of privacy, consent, and standing. All right, I'm going to move on to chapter 11 here, and chapter 11 has to do with special needs and administrative searches. Now, these are searches that don't typically fall in our normal realm of searching, but they either have a special need in order to protect the safety and security of someone, or it's done for a completely different reason than to find evidence. So, in 1989, the Supreme Court identified special needs that government entities might have that require search for purposes unrelated to law enforcement. And these types of searches do not require probable cause or even a search warrant. And then the definition of administrative searches, and these are done not as part of a criminal investigation, but are related to the special needs of the government or the community. So I'll talk about that here in a minute. So here's some examples. Security screenings at airports, courthouses, public buildings, or places. The government has an interest in maintaining the safety and security of that courthouse. They're not trying to find evidence. They're simply trying to maintain the safety and security, so therefore they have the right to search people and things coming in to those locations. So I mean, I think that makes sense. Border searches are the same, basically the same idea. Is that we have a vested security interest in making sure that illegal people and illegal things don't come across our borders, so therefore we can search people coming into our country to make sure they don't have illegal stuff or they're not illegal or whatever. Roadblocks, DUI checkpoints is considered a special search, although they're very limited. But no probable cause and no search warrant is required for those as well. And also like inspections, fire inspections, health inspections, motor vehicle inspections, school inspections or housing inspections. If you live in government housing, then you basically when you sign your lease, they say that we can come in and inspect at any time. And sometimes they'll give you notice, depending upon the state law. Sometimes they may not. If you own a business, the fire department has the right to come in and inspect that business to make sure that you are not blocking doors or in violation of the fire code or something. Same way with the health department. They can come in and check if you run a restaurant, they can check your food preparation and your food storage to make sure that you're not potentially going to cause harm to somebody through bad practices. Some states have motor vehicle inspections to make sure that the cars are safe on the road. Tennessee and Alabama, they pretty much let any old thing on the road, but you go up to our neighbor to the north, up in Virginia, they have some pretty stringent vehicle inspections, and if your car doesn't pass inspection, you can't get a tag on it. And then if you get caught driving without a tag, it's very likely you could potentially get arrested in Virginia for that. I mean, Virginia is one of those Commonwealth states. Anyway, they have a different style of government, a different set of rules and regulations than what most other states have that are not considered Commonwealth. Search warrants of closely regulated businesses. So search warrants are generally required for the administrative searches of commercial property. So just because it's a business doesn't mean you don't have to get a search warrant. But search warrants are not required for searches of closely regulated industries such as places that sell alcohol, adult-oriented dancing establishments, massage parlors, maybe tattoo shops, things of that nature where that's something that's pretty closely regulated by the government. Then they can come in and do an inspection to make sure that you're in compliance with the rules. And if you're not, then you could be cited into court for that. Or if they happen to discover, and here's the interesting part, during any of these special needs searches, if they discover contraband or something illegal during the course of it, then that is seizable, and then you can be charged with that. So I guess the moral of the story is if you are operating a business where that may be closely regulated, or you are subject to some of these special needs searches, don't break the law, because you're just inviting them to find out how you're breaking the law, basically. All right. So New York versus Berger from 1987 basically set forth 3 requirements for conducting these searches of closely regulated businesses. One is that there must be a substantial government interest that informs the business owner of the regulatory scheme to which the inspection is to be made. The inspection without a search warrant must be necessary to further the regulatory scheme, and the regulatory law must perform the 2 basic functions of a search warrant. It must advise the business owner that basically a search is going to be made according to the law, and it must limit the discretion of the inspecting officer. So they can't necessarily, let's say you live in an apartment attached to an adult-oriented dancing establishment. The apartment, you would have a legitimate expectation of privacy in, and the actual business part you would not, as far as being regulated. So the officers that come in to do the inspection for the adult-oriented dancing establishment could not come in and search the apartment attached to that building without a search warrant or consent. Make sense? Drug testing, that's something people do on a regular basis. If you're in certain occupations such as police work, bus driver, trained engineer, whatnot, yeah, you're subject to drug testing, and that's a pre-employment condition they usually tell you also. It says private businesses may conduct drug testing of employees without addressing Fourth Amendment rights, because it does not apply to searches of private persons. The Fourth Amendment does apply to government employees, and that's an interesting one there. School-related drug testing, as far as athletes, that is something that is allowable. They can't necessarily test every student in the school, but if they're on a sports team, they could potentially test them to make sure that they're in compliance with the extra rules from the State Athletic Association. Work-related searches in government offices. Private employers may make work-related searches of employees' desks, files, and company-owned computers as they wish. So if you're sitting at a company computer, or sitting at a company desk using a company computer, and the government or the agency or whoever it is you want to work for wants to come in and search that desk and that computer, they can. There's no problem with that. Now, if I'm sitting at a government-owned desk using my own private laptop computer, they cannot search that. They cannot search my bags. That's in my government office. They can only search the property of which they own. So public supervisors have wide latitude to search public employees, offices, desks, and files without a search warrant or probable cause. The Ortega rule, though, says work-related searches in public safety or government office, that they have a wide latitude to search, but there is a greater justification needed to search personal items such as briefcase, handbags, backpacks, etc. They could potentially search your private items that's located in those offices. However, they're going to have a much greater justification to do so. They're going to have some specific and articulable facts, I would almost guarantee. Roadblocks, car stops, I mean that makes sense to us. That's a specific that's a special need of the government in order to detect drunk drivers, verify driver's license, insurance, catch fugitives, or intercept illegal aliens. So car stops may be allowable near the border as part of those special needs border searches, and they may not necessarily require a probable cause to do the search. but let's say in Alabama, we don't have a international border in Alabama, so therefore a car stop in Alabama would require probable cause in order to search the car, unless you arrest someone out of the vehicle and you tow the car. Then you can inventory the car, and anything you find in that inventory could also be used for criminal proceedings against the defendant. But you can't just stop a car because you want to search it. If it's right on the border, perhaps you can. You might be able to justify that. But as far as roadblocks goes, that we're not really searching the car like we would if we arrested somebody out of the car and searched it incident to that arrest. But you are stopping the person. You're impeding their movement. You're asking them to show some paperwork, and you're trying to make a determination if they're potentially intoxicated. It's still considered a seizure and a search, but no probable cause is required to do it as long as it's brief and is limited in scope and duration. All right, sham roadblocks. Interestingly enough, these have repeatedly been upheld by the courts. Law enforcement may post fake notices about drug checkpoints so that motorists will discard drugs and be observed doing so by law enforcement officers. We did this in our county. It's probably been 20 years ago at this point. We put signs up that there was a drug checkpoint ahead on the interstate, but yet we had officers who were hiding in the bushes just between that sign and where the alleged checkpoint was going to be, and they were watching the vehicles that threw things out or turned around, went through the median, and then they were radioing to the cars to go stop those cars, or and then they would retrieve whatever the items were. They actually caught quite a lot. The Supreme Court says, hey, you can do it. Yes, the police are lying to you, but if it forced you to abandon some property, so therefore the search of that property is the exclusionary rule does not apply. But if you saw the vehicle that property came from and that property is in fact illegal, then you should be able to stop that vehicle and make contact with the driver and continue to investigate that. So sham roadblocks are okay. Public housing projects, already talked about that. Border searches, already talked about that one. Corrections and prisons. Typically you go onto that prison property, they tell you, hey, everything is subject to search. So, you've been warned when you drive onto the property, so expect it. Obtaining evidence in foreign countries. When law enforcement in a foreign country obtains evidence of a crime committed in the U.S., they should comply with the laws of that, and that should be country. Generally, the American legal standards do not apply to the seizure of that evidence. So American courts have refused to use evidence obtained by foreign governments if the conduct used to obtain the evidence shocks the conscience of the U.S. courts. So, for example, let's say John Doe gets stopped in Mexico, and the Mexican authorities beat John Doe up in order to get him to provide evidence of a crime, and he does, and then the Mexican authorities just turn over John Doe and the evidence of the crime to the U.S. authorities. And the courts have said, well, we don't allow beatings to coerce confessions in the United States, so therefore we wouldn't allow that to be admissible in our courts either, because the conduct that the Mexican authorities use would shock the conscience, if you will. So sometimes if they use decent means to obtain the evidence, it probably would be admissible. But if they use those means that shock the conscience, then it probably would not. All right, I'm done. I probably went over a few minutes in what I wanted to, but that should help you clear up some of these concepts that are in these particular two chapters. And I'll look forward to recording another video for you next week. Have a good week, guys. Reach out if you need help. Bye-bye.